The America First Legal Foundation, combating the left's radical agenda.
Fight for the American people, defend the Constitution, and save this nation for the next generation. Hello, and welcome to this week's episode of The Arena. I'm Gene Hamilton, president of America First Legal. This week, we have a very, very exciting guest, like we always do. But this week in particular, I think you're going to enjoy it. So without further ado, it's my distinct pleasure to introduce the Assistant Attorney General for the Office of Legal Counsel, Elliot Gaiser. Elliot,
hey,
thanks for joining us.
With you, Gene. Yeah, it's great to be here.
That's awesome. So, look, I uniquely know a lot about what your office does, what your position does, given a lot of things I've done in my career, but most people don't. And it's, unless you've actually interacted with the Office of Legal Counsel or you've served in the executive branch, most people don't even understand what it is that you do on a daily basis. And dare I say, I think that a lot of courts don't even quite understand. And by courts, I mean judges and the law clerks that work for them. Some of them do not seem to understand your role, your office's role within the executive branch. So I always like to try to just start asking guests, who are you and what do you do?
Well, thanks, Gene. As you said, I have the privilege of serving as the 27th ever head of the Office of Legal Counsel, an Assistant Attorney General. There are several Assistants Attorney General at the Department of Justice. We oversee different components. My component, the one-sentence distillation, is that we are the General Counsel of the Department of Justice and the outside General Counsel for the entire federal executive branch. For the lawyers, law clerks, judges, perhaps a better explanation is that you could imagine a world where the judiciary, we have three branches of government: the Congress legislates, the president, the executive branch executes, and then the judiciary hears cases and controversies. You could imagine a scenario where the judges in this country provide advisory opinions. There are systems that allow them to provide legal advice, but in this country, you can't go to a justice on the Supreme Court and say, can you give me some legal advice on how you might rule on X, Y, or Z? In the same year that the American people, 1789, ratified a constitution that deprived the judiciary of its advice power, they empowered, through their people's representatives in Congress, in the Judiciary Act of 1789, an attorney general to have that advisory opinion power to the president and to the heads of departments. Now, since then, the attorney general has delegated that power of giving advisory opinions to an assistant. And that's my job. I provide those binding legal memoranda, and that's what my office is probably most known for in the media, the headline-grabbing news that we publish, memoranda opinions that bind the executive branch, and we're the last stop in most instances on the view of the law for the executive branch.
So that's a really good explanation. And I hope everybody at home caught it. Because I think that there are a lot of law students, there are a lot of young lawyers, there are a lot of practicing lawyers, again, even people who should know better, who don't understand your function, and they don't understand. It seems like kind of like there's the Wizard of Oz is sitting in this room, right? And it's this mystery, it's this mysterious place, but it's staffed with real people, real smart people who do hard work day in and day out.
Yeah, I would say that I am so privileged to work with attorneys in my office, the career and political attorneys who work for OLC. They are some of the most dedicated public servants I've ever met. And there's a thing about lawyering. Every lawyer takes on the role of both advocate at some point in their life and counselor. If you think of a dial, maybe your dial on your radio in your car, you could turn it all the way in one direction to advocacy. That's what we often think of as lawyers in the courtroom, saying, my client has a case to be made and I'm here to make it most persuasive, view of the law, view of the facts. But at the same time, lawyers also have to, at some time, turn that dial to the other direction as the counselor, under the protection of attorney-client privilege and confidentiality, to take their client aside and say, I can make the best case that I can for you, but here's where you really stand. Here is how good your case is, and I think you better settle. Or I think that this transaction that you're trying to engage in, or this merger, is really fraught with legal risk. and clients need both advocates and counselors. Now, the Office of Legal Counsel turns the dial of counselor as far as it can go. We are not advocates at the Department of Justice's OLC. We are not a litigating division. We're not the Solicitor General advocating to the Supreme Court. We're not the civil division in trial or appellate courts pressing the case or defending the United States in the judiciary. We're not the Office of Legislative Affairs making the case for the executive branch or for the Department of Justice to Congress. We're here to provide confidential advice to our clients in the executive branch. Now, sometimes that's the Attorney General. Sometimes that's the White House counsel or the president. Oftentimes it's the general's counsel of the various agencies. So EPA has the general counsel, the War Department, the State Department. They have their own in-house counsel, and they can provide most of the legal analysis that their secretary or deputy secretary needs, the day-to-day operations. But there are some questions that are so thorny or so novel or so consequential that they need an expert to come in on the outside. And so OLC is almost like the boutique law firm that is brought in to resolve these most complicated and challenging legal questions. And sometimes there are disputes within the executive branch. So one agency and another agency might see the law, same statute, same provision of the Constitution, and reach different conclusions about what it means. Well, they don't want to resolve this outside of the executive branch. That's really inappropriate for the judiciary to resolve a dispute in many instances between, for example, the Treasury and the State Department. So where do they go? Well, OLC has the quasi-adjudicative power to hear arguments from both sides, these very complicated questions advanced by also Senate-confirmed general counsels to their agencies. And then we will take a hard look and provide the best reading of the law in the greatest tradition of OLC. And part of the privilege of serving in this role is the privilege of standing on the shoulders of giants. Some of my predecessors include Chief Justice Rehnquist, Justice Antonin Scalia. There's only 27 of us who have been confirmed by the Senate, and only about half of us are still alive. And so it's a small group of people that I have the privilege of serving in their footsteps, and I do my best to uphold the highest traditions of the office.
That's quite a humbling list for you to follow. How large is the department? Like what's sort of a typical day of, if there's such a thing as typical day?
Well, so the Department of Justice itself has over 100,000
Right.
employees.
But
my component is relatively small. We have about 30 lawyers on staff at the moment. And you compare that, for example, to the civil division where there are over 1,000 lawyers who work on a day-to-day basis. So it's a fairly small group, and lots of law firms will tell young associates, you'll get great experience here because we leanly staff our cases. It'll just be, you and a couple of people. That's true of OLC as well. It's usually an attorney advisor and or a counsel in my office, a deputy, and then me on most of our legal problems. And so it's a small group, but as I said, these are some of the sharpest lawyers in the country who work at OLC, and it's a privilege to get to lead them.
It sure sounds it. And I think, I was talking to somebody about this the other day, when they were saying, well, what's the difference between your office and, I've heard about a Solicitor General. I said, what, one of the ways I explained it is it's a bit of a timeline difference, meaning the Solicitor General represents the United States in court to adjudicate an issue. OLC is more, the earlier on the timeline to resolve issues, give advisory opinions, counsel, and so forth, hopefully before it becomes an issue. Is that sort of a fair way to explain it?
That's an absolutely fair way to explain it. I think all of law operates on sort of a time scale. At T0, you have policymakers who are thinking, hey, what would be a good approach to this problem? And then at T1, we're usually the first lawyers to take a cut at that legal problem and provide our best view of the parameters. If you want to be exceptionally esoteric about it, I like to think about Archimedes. He apocryphally said, if you give me a place to stand and a big enough lever, I can move the world. Well, policymakers in Washington have a lot of policy levers to move the world. but they also need to know where they stand as to the law. And so that's often what we do at the very outset. Now, so, in addition to the opinions that we provide, we often are reviewing presidential executive orders, proclamations, any presidential memoranda, as well as attorney general orders and orders from the deputy attorney general. We will look at those. We call it form and legality review. So we're looking at them to make sure that they conform with the traditions of how these orders look and the precise language that is important to use. And then we're also making sure that they fall within the bounds of the authority of those who are issuing the order. And we assess them for litigation risk and provide candid feedback about what we think puts them on the firmest legal basis so that they stand in the firmest possible place.
Right.
And we're also not a policy-making component. There are parts of the federal government where lawyers help with policy, and we don't pass judgment on the wisdom of any particular proposal. That's really immaterial to our work. We're here just to tell you what we think the best view of the law is and to assess the legal benefits and risks associated with one course of action compared with another.
So a lot of times people talk about judicial precedent, right? And I would imagine that you're not just motivated by judicial precedent, but that you have your own historic precedent that is unique to your office and the guidance that you give to whether it's the president or other agencies.
Yes, executive branch practice is a source of information about what the executive's historic powers happen to be, what Article 2, which is where the president's powers are vested, what that means and how it's been liquidated over time. And the opinions that my office and the Attorney General, before my office existed, or still, Attorneys General can still sign opinions themselves, and OLC will help with that. Opinions have precedent within the executive branch. So when me or one of my deputies, when we sign an opinion, that is now binding on the entire executive branch until me or one of my successors or the Attorney General or the President overturns it. And we do not depart lightly from OLC precedent. We give all of our opinions respectful consideration. And that's in part because we think that it's correct on the merits, but it's also because the executive branch, this president, subsequent presidents, will be relying on the consistent, long-standing advice that DOJ has given about the scope and ambit of their powers and the statutes that the president is tasked, charged by the Constitution to take care that he faithfully executes the law.
Could you talk a little bit more for some of our viewers at home who might not know what an OLC opinion is and explain sort of, what it is, what the process is for writing one, and what it means after it's written?
Yeah, so OLC opinions can come into existence a number of different ways. The most common one is someone in the federal executive branch, so maybe the State Department's legal advisor or the general counsel of the Department of War or the White House counsel, will ask OLC for advice. And we provide confidential advice all the time. And most of that advice never becomes a published opinion. It continues to be attorney-client privileged communications where we're providing them with candid views on the law. But sometimes it becomes helpful both to them and to the executive branch to have that reduced to writing and published so that the public, so that Congress and the courts and subsequent executive branch officers can see what we think the law means. So I'll give you an example of one of them that I was privileged to work on. The Department of Health and Human Services and the Housing and Urban Development Department asked in 1997 for an opinion about the meaning of the 1996 welfare reform. Now, you may remember the contract with America, Newt Gingrich and Congress ran on reforming welfare. President Clinton agreed that there were necessary reforms and ultimately signed into law the 1996 welfare reform, colloquially known as workfare. And the signature of that was that if you're an able-bodied American and you're able to work, you are eligible for welfare only if you are working, seeking work, preparing for work. But it also had certain eligibility requirements for those who are not citizens of the United States. The president and Congress made clear in that law that you should not seek to come into the United States shores because you want to take advantage of the generosity of the American taxpayer. And instead, you have to satisfy rigorous eligibility rules for accessing these welfare benefits. But in 1997, HHS asked if those eligibility requirements for non-citizens applied to all means-tested welfare programs, which is what the law says, or just those that are funded through, and this is a very inside baseball, mandatory appropriations. Now, the mandatory discretionary appropriations inside baseball for Congress, that's the difference between what we might think of as entitlements like Social Security, where Congress has passed a law that says we have to fund it. It's automatically funded until that organic statute is repealed. Discretionary funding goes through the ordinary budget process. It's the kind of thing that gets renewed, every year or 2 years or so. And so OLC looked at the definition of means-tested public welfare benefits and rooted through the legislative history to conclude that it was ambiguous. And we didn't know whether it applied to all forms of welfare or just those that are funded through mandatory appropriations. And as a consequence, they deployed something known as Chevron deference, which, if there's ambiguity in the law, allows a court to defer to an agency's interpretation if it's reasonable. Well, what that meant is that discretionary programs were cut off from what Congress passed, the president signed in the workfare reform, and something like $40 billion a year flowed to non-citizens without regard to the eligibility requirements that Congress and the president had placed into law. And so close to the beginning of my time as the head of the office, HHS and HUD asked me, is that still the best interpretation of the law? And there'd been an intervening change in the law. The Supreme Court, you may have heard, overturned the Chevron case in a case called Loper and concluded that it is not appropriate to seek ambiguity and then defer to agency interpretation. So that created an opportunity for me to reassess the first best meaning of the law. And we don't typically look for ambiguity in the legislative history. You only resort to legislative history, if at all, in certain narrow circumstances if the meaning of the words enacted by the legislative branch are unclear. And here, means-tested welfare benefit is clear. Look at a dictionary. Look at what people in 1996 understood that term to mean, the original public meaning of that text, and that's the end of the story. And that meant that I overturned a past precedent, and I looked at whether there were reliance interests in that, and I concluded that no, there were no legitimate reliance interests in non-citizens to obtain welfare in the United States without regard to the eligibility requirements, just because OLC said so in 1997, and that there were reliance interests on the part of the American people. They rely on the protections around the public fisc, around their tax dollars. And that was ultimately what needed to prevail, combined with the best view of the law enacted by Congress.
Well, bravo for you and Loper Bright. Man, that was like perfect application. Perfect.
Yeah. So one of the things that flows from that explanation of what happened in the late 90s brings up a more thematic issue that, at least in my experience, I've witnessed and we've seen, and I'm not just saying just when we were in power, I'm saying when we're out of power as conservatives and on the other side as well, which is when people in agencies, whether it's general counsels or other general's counsel, I should say, or otherwise, interpret statutes and exercise agency power in ways that are completely at odds with the plain text of the statute. And so we have seen in many, many instances, sadly, in a lot of different departments and agencies, there's a separate concept we can talk about in a little bit, malicious implementation by certain personnel of different statutory terms and regimes in a way that's contrary to what Congress intended and what the president signed into law. But really and truly, getting an answer to some of these departments and agencies that is actually the best reading, of the plain text of a statute. Because if you think about it, and this is something that has always driven me crazy, since I get on my soapbox for a minute here, is that every time, the way that our system was designed, the way that our founders designed our system, was that obviously Congress writes the laws, and they debate them, supposedly, maybe not always these days, but they debate them, and someone wrote those words, whether it was legislative counsel, whether it was some staffer, whether it was the congressman or senator, him or herself. They wrote the words. Everyone read the words. In theory, everyone read the words and decided those are the words that we want. This is what we want to do. We are going to pass this. We are going to vote. So a lot of political capital, a lot of energy goes into that process. Then it goes to the president, and the president decides whether or not they're going to veto the law or not, whether they're going to, just sit on their hands and let it become law, whatever the case may be. That is the process that is set up from the process of creating a law in the United States. And so when people look at the words, look at the plain text of a statute or a statutory provision, and they say, yeah, well, I know it seems pretty clear, but actually, I think they were really trying to say this, or actually, they really didn't intend for that result. And a lot of times we see this and come up from courts. And a lot of times I've seen this personally in the immigration context, where people like outcomes-oriented results, and they interpret statutes in a way that is contrary to what Congress put into the statute, what the president signed into law, and they read the words in a way that gets them to the result that they want. And I think that the Office of Legal Counsel, in particular, has a unique role in ensuring that, at least when they're asked, they're not always asked by some of the departments, especially in other administrations, that is actually, in fact, what happens. That, in fact, we give due deference to the words that are actually written. We interpret the ordinary plain meaning of the text as it was understood at the time of the adoption of the text. And as you indicate, you only look at legislative history in extraordinary circumstances. Can you comment on kind of what you've seen in some other examples, especially in some of the other cases, some of the other opinions you guys have issued, of other instances in which you looked at a statute and said, oh my God, there's no way that this could be read any other way than the way that we're doing it. And yet somebody had interpreted in a contrary manner for a long time.
Well, I think, Gene, there are many instances that you can point to where agencies want to stretch the boundaries of their authority. And sometimes there's a political reason for that. Sometimes there's an ideological one. And sometimes it's simply no one has really paid attention. So on the theme of means-tested welfare, probably some of you remember the Obama phone program. The Federal Communications Commission, the FCC, has a program called Lifeline. And they started it through regulation. Congress eventually ratified and passed a statute that gave them authority to provide subsidies to phone providers, telecommunications providers, so that they can provide discounted cell service to Americans. And, Congress made the judgment that that was important to give people a lifeline. But part of the assessment is into the means or the financial wherewithal of those who are eligible or not. And so the FCC asked me, after I did my opinion about HHS and HUD, does the workfare non-citizen eligibility strictures, do they apply to the Lifeline program? And so no one had looked at that question before. But if you apply the plain meaning of what Congress enacted to the other statute, then and combine them, you see that the Lifeline program is a means-tested federal welfare benefit, which means only those who are eligible to receive it can receive that benefit. Now, every American pays for that benefit. You could see it on your phone bill, universal service fee. And for years, that program had been going out without carefully checking to ensure that ineligible non-citizens weren't taking advantage of the FCC Lifeline program. And so we put a stop to that. We said that's not what the law means. The law's plain meaning is you have to actually abide by these protections that the people's representatives in Congress placed around the generosity of the American taxpayer.
Yeah, it's just to me, it's a sad reflection of reality, that people wouldn't have paid attention to that. That somebody in the FCC until now didn't even think to ask the question, or didn't even think to raise the issue. And that, oh, well, you know what? Let's just go ahead and let this stuff go on out. And, we hear rumors that there's issues with illegal aliens getting Obama phones and all the other stuff, but we're just not even going to pay attention to it. We're just not going to investigate. Or maybe they did. Maybe they thought about it and they looked at it and said, we're just going to look the other way. So that leads me to another issue, which is you've described the role of lawyers, right? And we all have different hats that we wear at different times. And one of the things that OLC does, as you say, spends most of nearly all of its time is on counseling, in telling the client, whoever the client may be at that point in time, whether it's cabinet head, whether it's the AG, whether it's the president's lawyers, precisely your best reading of a situation, and you assess litigation risk. But ultimately, of course, as a counselor, you are not the decision maker. And I think that there are other lawyers who occupy different seats, and it's not just in the government, it's in the private sector too, who then think that they are then the decision maker as well. And so your job as a counselor, your job as a lawyer is to provide your client advice. Let them know about the risks, let them know about the positives, the negatives of a particular course of action. And then ultimately, the client has to make the decision. But I think that there's a lot of lawyers out there who don't understand that. They think that they're the decision maker. And it can be in the private sector. It can be a general counsel's office of a major corporation. Or it could be a partner at a firm. Or it could be anyone, anywhere, who think that they're ultimately the decision maker. And, when you're in a position of providing, advice and counsel, can you talk a little bit more about what are the things that you think are best for a lawyer in any setting to give to their client to be able to make the best decision that they make according to their desires?
Well, as you said, Gene, every lawyer has different hats that they wear. Sometimes your job is to advocate for a client's position. And we have concluded in the Anglo-American legal tradition that one of the best ways to discern the truth is through the clash of opposing advocacy. That our system of juries and trials, where you have counsel on both sides making the best view of their client's position known to a neutral arbiter, is the best way that we can understand, through the frailty and imperfectibility of human nature, what is true and what is just and right. There's also the role of counselor, and my job in OLC is to provide a candid assessment objectively, without the lens, the hat of I am your zealous advocate. Now, it's true for all lawyers, you have certain duties. You have a duty of candor. If you believe something to be true, you see something that is at risk, you say something about it. But lawyers are also not omniscient. And so, as you said, not every legal problem comes to OLC, and nor could it. We have Senate-confirmed general counsels in each of the agencies, and the U.S. attorneys provide frontline legal defense and prosecution work. We have a small sliver of the set of problems legally that face the executive branch. But when a problem comes to you, you have to, without fear or favor, candidly assess the best view of the law, weighing counterarguments, and then provide that assessment. And if the client wants your view to be reduced to writing and published to the American people. Now, we've published about 30 opinions. To my knowledge, that's the most opinions at this point in a presidency that have ever been published by OLC. We're one of the most transparent heads of the Office of Legal Counsel, one of the most transparent departments of justice under Acting Attorney General Todd Blanche in American history, because we want the American people to see that the lawyers in the room are providing our best view of the law and then submitting them, as the Declaration of Independence says, to a candid world so that they can see and assess for themselves. And the ordinary people of the country, who are the ultimate repository of the sovereign power. The people in this country are the ultimate client. And elected representatives are their agents. And I'm an agent of the agent. The president is my principal. The attorney general is my principal, insofar as I provide advice to them. But at the end of the day, DOJ's ultimate client is the American people. And we're here to provide them with the best legal services that they can get. And so that's why we publish the opinions that we do. We want them to see as best as possible. Now, there are some things, where the client is still assessing their options. You can't publish an opinion when it's a live legal question. And sometimes OLC has a memo about best practices. We usually don't opine on things that are already in litigation. It's not our practices once something is, in the hands of the litigator to try and insert ourselves. It's usually before something has come before the independent coordinate branch in Article 3 of the federal judiciary that will provide our advice.
So I have one more question, which is, you have not always obviously worked in the Office of Legal Counsel. You actually, in fact, came here with a background doing other things. So if you were to be telling a young lawyer or a law student today, in giving them advice, they said, you know what I heard today sounds like this is my dream job. I would love to go work at the Office of Legal Counsel. What practical steps would you tell them to take today and going forward to pursue a career there?
That's a great question. I think the most important thing is applying yourself to knowing the law very well, and then taking on the types of experiences that give you that robust legal training. So clerking for a federal judge, most of the lawyers in my office have done that, sometimes more than one judge, because that's excellent training to provide your best view of the law to a jurist who will ultimately, because they wield the commission signed by the president, confirmed by the Senate, decide what the law is on a given question and apply it to that case or controversy. Practice at the highest level. I think advocacy and counseling in a private law firm can be fertile training ground. Many of my lawyers started in private practice. And then I think a sort of academic and intellectual curiosity. You need to be able to chase legal threads to their origin points. You can't just accept that some court somewhere has said this is the law without analyzing how did they get there? What precedents did they cite? What precedents did those precedents cite? Because the law in this country is the Constitution and, of course, the statutes enacted, signed by the president, but it's also judicial precedent. It's also the fertile soil of the common law. It's this beautiful tradition that comes to us across the Atlantic from our forebearers, and in many ways dating back to the Roman law. And being able to trace those ideas to their origin point is imperative. And then you also have to have a certain level of courage. And that's true in any legal job, but in this job, you have to at some point tell someone who really is highly motivated to do something, actually the law doesn't give you the authority to do that. There's a statute or a constitutional provision or a precedent that squarely answers the question in the negative. And I can't magically pull a rabbit out of a hat for you on that. If there's an argument to be made for something, that's one thing. But sometimes you have to be able to, without any fear, candidly and respectfully say, here are the borders of the law and what that means.
What a segue, because I was going to ask you, when you counsel, I think we'd all agree that sometimes counseling isn't just a yes or a no, but it's you can't do it this way. The law's the law, but you can do it this way if you do X, Y, and Z. So part of being a good counselor is being brave enough to tell the truth of no's hard to receive, whether you're an attorney, a client, a parent, whatever, what have you, right? We all know that. But sometimes there's a way to do something that's lawful that is in keeping with the wishes of your client. First, the president and the president's ultimate client. All of our ultimate clients are the American people.
Yeah, there is a lot of truth to the notion that if you can internalize and understand carefully what it is that the client is attempting to do, you can find them the best available path through the thicket. And it might not be the initial way that someone thought was the best way to go. And sometimes you need an act of Congress or you need a change in judicial precedent, but oftentimes there's a way to find a solution legally if you're creative, if you're thoughtful, and if you're fearless. And so much of the dignity and I think the satisfaction of being a good lawyer is that creative thinking. And you're trying your best to mete out your absolute duty to say what the law is with your strong duty to help your client
Exactly.
do what they've been elected to do.
Yeah, I mean, that's what I was actually going to ask about also, which is lawyers they can develop reputations for being the people who just get known as saying no, 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 no. Nope, can't do that. Nope, can't do that. But when you're in the position of a counselor and you, as you indicate here, you know your client's ultimate objectives, it can be good. It can be a good thing to say, hey, probably not that way, but I understand where you're trying to go. And I think we could probably go here, there, and the other place to get you to your ultimate objective, to your ultimate goal, and try to help create a roadmap, help create a path forward to yes. And I think that there are not enough lawyers, this is my pontification again, who understand that saying no, just outright no, and just shutting a client down, don't really understand that that's not, I mean, sometimes I guess it could be your job to say absolutely not, no, never, this is never going to be lawful. But it's so much better to give your client, hey, like, let me understand what you're trying to do here, and let me try to help find a way. And if there is one, we'll find it for you. And that's a very unique kind of role for a lawyer in our society, as somebody who helps and understands a client's goals and tries to help them get there.
I think that's the best tradition of lawyering. You are trying to understand the client's perspective and you're trying to find the lawful path for them. Sometimes there isn't a lawful path, and you have to be honest about that when that's true. But you also can't quit too early. And I think there are some lawyers that get the reputation of just saying no. It's safer in some respect to just say no to everything. But that ultimately is self-defeating, because what you're trying to do is be the effective agent to the principal, even when you're counseling them in an objective and unbiased way and not advocating for them.
Right, because then ultimately, if your client hears no too many times, what are most clients going to do? They're going to stop asking, right? I'm going to stop asking you. And so, the role of a lawyer is to try to help be the resource to the client. And again, this is just whomever you're talking about. I'm not just talking about in the government. This goes across the private sector for corporations, firms, municipalities, state governments, everywhere in between. The best thing that you can do is to say, if the answer is absolutely no, hey, I have run down every single possible lane here.
And sometimes that actually really does help clients, because you don't want to burn resources on something intellectual, the time of your employees, that is a total dead end. And sometimes there are clients who receive no as a gift. And there was the chair of the EEOC asked OLC whether or not their guidelines interpreting disparate impact liability under Title VII for private and public employers was consistent with the Constitution as it was best understood. And the answer that I provided was no, actually, those guidelines are not currently consistent with the Constitution. And here's how you bring them into conformity with the text of Title VII as Congress wrote it, and with the principles of equal protection and equal treatment. Because so much of disparate impact liability had started to make employers see race consciousness as a safe harbor. Because if you have a neutral hiring practice, the top 10% of my sales force is going to get promoted. The bottom 10% of performers are going to get laid off in a reduction in force. HR and the lawyers inside would start to say, hey, there's legal risk here, employer, if the color of the skin or the race or sex or national origin or any of the protected characteristics aren't diverse enough among those promoted, or among those who are reduced. And that starts to mean neutral, merit-based, equal treatment became a source of legal risk. And that's what the EEOC under past administrations had been interpreting Title VII to do. And this had really started to infuse race-based decision-making into everything that many employers were doing. And so the EEOC asked, is this constitutional? Is this lawful? And we said, well, here's how you make it lawful. Disparate impact, statistical disparities can be a basis of liability if they are a strong signal of disparate treatment. If you're treating people differently on account of their protected characteristics. Yes, statistical evidence can be a lawful way to show that. But statistical disparities alone, you can't stop there and impose liability there. Instead, you need to give the business an opportunity to propound a legitimate justification. And if it's a rational business justification, then the challenger, the plaintiff who's suing to try and impose liability, or the EEOC trying to impose liability through an enforcement action, needs to show an alternative employment practice that has less disparate impact, less statistical disparities, but meets the employer's legitimate, normal business judgment goal just as well. And to reach that conclusion, we weren't alone. The Department of Justice, OLC, we looked at precedents from Justice Kennedy's majority opinion in a 2015 opinion called Inclusive Communities that read the Fair Housing Act of 1968 as imposing disparate impact liability only with that type of safeguard, the alternative practice, the legitimate goal that was being pursued. And the recent opinion from Justice Alito, 6-3 for the Supreme Court in Calais versus Louisiana, which held that the Voting Rights Act of 1965 was only constitutional if the challengers of a voting practice, including a map that draws the borders of a congressional district or a state legislative district, if they could show an alternative map that has less impact on minorities, but also met all of the legitimate political goals of the state, protecting incumbents, communities of interest together, maximizing partisan vote share just as well. And so we read the 1964 law that Congress adopted together with the Supreme Court's interpretation of a 1965 and 1968 statute that imposed those same limitations. And the answer that we gave was no, actually, it's not constitutional how you're doing it, but here is a roadmap for how you can constitutionally ensure that our colorblind Constitution and merit-based employment practices and an opportunity society that Congress enacted into law is the law of the land.
Well, that's absolutely fabulous.
I was just going to say, you had an incredible career. Obviously, you're doing amazing things. I would love to know, in a different life, maybe, what would you be doing?
Well, I've always loved writing and I've always loved communicating. And one of the reasons that I was drawn to the practice of law is that it was a way to reasonably and effectively and persuasively take complex ideas, boil them down, and try to place them in the best view. And I love public speaking. I love meeting new people. I love communicating. And so one of the things I love about my current job is that I get to meet with the lawyers and the policymakers around the executive branch and dialogue with them. Human beings are different from all kinds of creatures because we have the capacity for reasoned speech. It's something that sets us apart. And the genius of the American experiment and our freedom of speech is that we welcome that debate and dialogue as a truth-seeking function. And so if I weren't practicing law, I would imagine it would be something that involved writing and speaking as best as I can to persuade people of what is true.
Well, I think we are done for the day. We have another segment on the show. It's Bad Legal Takes, which is actually probably part of your job, but that as applied, sometimes it can create some issues for government employees. So we don't want to put you in that position. But we've all enjoyed speaking with you today. It's been absolutely very intriguing. I hope folks at home paid attention and they learned something. If you're a young law student, young lawyer, you're a clerk somewhere, and you want to pursue a career at the Office of Legal Counsel, I think you actually have a pretty good roadmap as to what some of the most typical practices or the best practices to get there are. And I hope that you've actually also learned a thing or two about what the Office of Legal Counsel actually does. It's not a mystery box where things go to get resolved and come out on the other side as though there's not any human beings involved in the process. So, Elliot, thank you very much for joining us today. We really appreciate it, and we wish you well, and we know you're going to do great things.
Thanks so much, Gene. Grateful to be here.
Thank you very much. All right, now it's time for our bad legal take.
From viral bad arguments to headline mistakes, we're calling them out on bad legal takes.
All right, so our special guest this week, Elliot Gaiser, deals with bad legal takes, I think, probably a lot. It's a shame that he wasn't able to join us for this particular one, but I didn't want to put him in a bind. So let me tell you about our bad legal take of the week. Our bad legal take of the week, as often happens, involves a bad factual take as well. Let me read you a few statements. In October of 2023, the New Jersey Lieutenant Governor stated every voter should feel confident to participate in New Jersey's free, fair, and secure elections. New Jersey Governor also has said that here in New Jersey, our voters can be certain that we are working hard to make sure our elections are conducted in a way that bolsters public confidence in our democracy. People in New Jersey have also said voter fraud is extremely rare. In 2023, Governor Murphy dismissed calls for election integrity and said that those categorizing them as attacks on our democracy and spreading disinformation and misinformation surrounding our elections. This is pretty strong words coming from a lot of officials in the Garden State. So, are their words true? Are elections secure in New Jersey? Voter registration procedures secure in the state of New Jersey? Well, fast forward to today. Fast forward to this week. And what have we discovered? We've discovered that as the state of New Jersey has publicly admitted, thousands of non-citizens wound up on their voter rolls, and hundreds of those non-citizens voted. Now, that's quite a gap between the confidence expressed by the elected officials in the state of New Jersey about the security of their elections and their voter registration process and everything in between, to what actually was happening. And so my question is, and we can get into a little bit of the legal inner workings here as well. My question to my co-panelists here today is why? Why are they acting like they are so confident that there could never be an illegal alien or a non-citizen on a voter roll? Why is that such an extreme concept to them? Something that apparently, as we just saw, I'm sure the numbers are actually even more than what they're admitting, and that's just one state for one snapshot of time. How is it, why is it that we can get such a bad factual take and a bad legal take that somehow our elections are secure, there's no problems, nothing else needs to be done? This Save America Act that President Trump and the administration are pushing somehow is just not necessary because we've got everything locked down. How is it that the Democrats or the liberal leaders, this isn't a partisan issue, but they seem to have made it one, and so I'm being descriptive here in my discussion, is how does this happen? How do we get to this place where they are so confident in their procedures being secure, they are so confident that there are no flaws, there are no problems, and yet just this week they come to admit, oh, actually, there's thousands of people got registered to vote, and they blamed it on a computer program. Of course it's a computer program. Of course the computer did something wrong. Couldn't possibly be anything else going on. How is it that we got to this place, and what are the legal issues and the factual issues we should be tracking as they respond?
So, call me cynical, but my take is they never let the facts or the truth get in the way of their agenda. So what do I mean by that? I can give you an example. I am a born and bred Jersey girl. So my mom has voted by mail-in ballots previously, and I have gone with her to fill out the forms in Hackensack, New Jersey, which is the county seat. And when I went in, and we had ordered the forms ahead, and we were like following all the rules, went in, she filled out her form, and she had to show, goodness gracious, a driver's license, don't you know? And so we showed the driver's license, and I said, how does this work on day of voting? Surely you ask for a driver's license on when people actually come in person and vote.
Seems like a good idea.
And their answer was, oh no. I said, so wait, let me try and understand this. Somebody who has come in to fill out the form in order to get the ballot, which will then get sent to where she was, which is living with us at the time, she has to show a driver's license, but somebody who comes the day of does not, and they said yes. So I'm only sharing that to show you that there is zero logic, that this is a matter of pushing your agenda. That is what is driving this. And for those of us, and I say this in my personal capacity here as a conservative thinking is common sense thinking. You want to vote in this country, it's not a right, it's a privilege. And in order to have that privilege, there are certain proofs that you have to have when you go to vote, right? So that's how we think. It's common sense. They don't think that way. Theirs is all about the agenda. We've all talked about how many times that if letting people in and having an open border, as was the incredibly offensive practice under the Biden administration, was one in which Republicans would come in and vote, you could be darn sure that that border would have been like locked and the key thrown away. But it wasn't. It was people could come here illegally, stay here and vote in these certain states, including New Jersey, because it pushed the agenda. So that's my response. I can't give anything erudite other than to say it's agenda driven.
And it's so dishonest for them to come from the position that everything's perfect and there are no problems with the system. I mean, how many systems in the government, state and local, federal levels do we know that there are issues with? I mean, we can always make things better. So for them to say there's no issues, there's no, nothing, it's just not true.
Yeah, what this reminds me of actually is 2 years ago, during the 2024 election, there was a lot of attention rightly being put on the issue of non-citizens ending up on our voter rolls. Now, let's just make a few things clear. Registering to vote as a non-citizen is a crime. It is against the law. You're not allowed to do it. So that's one issue right there. There's a legal problem right there itself. But the lack of will and desire amongst the Democrats, in particular, the liberals, to do anything to verify, you would think that if they were acting with common sense, if they were grounded in a pursuit of truth and common sense, that they would say, you know what, we're so confident that there are no issues here that we're just going to do everything we can to verify that there are no citizens on our voter rolls. But they didn't. And so what did we do as an organization 2 years ago? Well, we sent out a battle plan to every single state across the country. And we said, hey, chief election official, guess what? There is actually a database that DHS maintains. And actually, there are federal laws on the books that entitle you to obtain information for any lawful purpose under federal or state law to obtain access to information about whether the immigration status of any individual in DHS's databases. And so we sent this plan. A lot of states ignored it. Some states acted on it. They sued. Some states prevailed. Last year, President Trump issued an executive order requiring a number of things to be done, encouraging more databases to be made available to the states free of charge so they could verify this. And so what happened last week? Well, the president came out and he announced a whole lot of things about things that undermine the integrity of our election, particularly in 2020, and some of the things that were being done in advance of the 2020 election cycle. But then what else came out? DHS said, hey, we've identified a few 100,000 non-citizens in just a few states that they said, hey, look, it looks like these might be non-citizens on your voter rolls. Why are these states so unwilling to just do the common sense thing? If you're the average American sitting at home, you're going about your day, you're taking your kids to, baseball or soccer or whatever, football, you're going to the grocery store, you're doing things. If someone asked you the question, hey, do you think that the federal government and that the state government knows who's on all of the voter rolls? What do you think that the person would say? They would assume that people are actually trying to do things to ensure that those voter rolls are safe, that they are actually accurate, that there are no
That we're checking things?
People are checking things. There's no illegal aliens. There's no dead people. There's no all these other things. People have moved. But in fact, it appears that that is not the case. So I know that our work here at America First Legal was very instrumental in helping to show that there is, in fact, a way to obtain this information under law for states, and that there is a way to, in fact, verify when you have known non-citizens in DHS databases. It is the opposite of common sense to not compare that list that you have to what DHS has. Why would you not do that? Doesn't that make sense?
Of course it does. And I think there are a lot of Americans who would say, yeah, we know dead people are voting. We know illegal aliens are voting. And for that, it's very dispiriting. And I think we've all seen this. There's a feel, why should I bother voting? My vote doesn't count. My vote's going to get, checked by somebody who's here illegally. So not only is it unlawful, and not only is it clearly agenda driven by the Democrats, but it's dispiriting to the American people whose right it is to be able to vote. And we do bring a lot of attention to it at AFL. Election integrity is a very, very important part of our mission, as it should be.
Yeah. I mean, it really is. It's alarming that people don't pay more attention to the issue of the non-citizens, because as a society, this is the most important privilege, again, we could ever bestow on any person, is to give them the privilege of being a citizen. For what purpose? So that they can vote, so that they can participate in the political process in the United States. We know that the Democrats and that the left are, why we all understand. Why is it they want more names? Because they want more eligibility to vote for people, whether it's through the mail or other means. They're not going to try to go round up a whole bunch of illegal people and take them to the polls. They're going to take them, they're going to obtain the ballots, and they're going to ship them in from the mail, just like they did in 2020, to be able to capture elections and make up the margins that need to be made. And so
they can keep power.
Right.
It's all to keep power.
Keep power.
Obtain power, keep power.
It, and then use power. And so, when Democrats or when elected officials are so reticent, when they are so enraged at the idea that they should be doing anything else to ensure that only American citizens, or eligible American citizens, are on their voter rolls, it should show you something. It should show you something as an American with common sense, that in fact, maybe there's more to the story than what they're leading on to. I don't know. But I think that that's a pretty bad factual take. It's a pretty bad legal take. It's yet another example as to why we need some serious fixes in this country, why we need to secure the integrity of our elections, why we need to make sure that no illegal aliens, no non-citizens are on our voter lists, and in fact, of course, also not voting.
I agree with you. And to get back to your original example, if we had to bet, or I'll say if I had to bet, the lieutenant governor, the prior Governor Murphy, and the current Governor Sherrill, they knew exactly what the facts were, right? And so why did she reveal this now? Like to get ahead of it because it was going to come out? Probably.
Yeah, I mean, I would like to think personally that the actions of this Department of Homeland Security, this Department of Justice, showing that in fact there is a problem, and that when there is a problem, as DHS identified, and the Department of Justice identifies and says, hey, this creates real legal liability for you. You have responsibilities and obligations to maintain your voter rolls under federal law. That in fact, maybe it's an example of lawyers. Who knows? Maybe it's an example of lawyers in New Jersey telling their client, you're about to get, something, and you better fix it and own up to it quickly before bad things happen. That's my hope.
We can keep on hoping, and certainly DHS and DOJ are doing the Lord's work. I really believe that.
Doing the Lord's work, absolutely. Well, this has been a fun episode this week for the legal geeks amongst us. Which all of us, especially lawyers, we all have a little bit of an element of us that is a little bit of a legal nerd, and we like to talk about kind of more esoteric concepts in things. There is no place like the Office of Legal Counsel anywhere else in the executive branch. There's probably very few places like it anywhere in the country. And so I can say that if you are, again, a young person, or if you are a mid-career person and you want to try to pursue a career in that office, I'd highly encourage you to do it. Based on my personal interactions with that office, my personal dealings with that office, across many, many years of government service, I think that it's a wonderful place to be. I think that the work they do is very important. And I think that hopefully, again, you learned something from this episode this week about its operations, the way that they view the world, and the way that they try to advise their clients. And again, ultimately, the most important thing to me here is for everybody to understand they act as the counselor, but ultimately the principal makes the decisions. And that is a thing that as a lawyer, a lot of people forget. If you're not the client, if you're not the principal, you don't make the decisions. Your job is to try to help your client figure out what they can do and how they can achieve their goals. Thank you for joining us this week. It's been fun. We'll see you all next time. We have a very special guest next week from the Sunshine State, so stay tuned.